the issue. Now that I'm in private practice, I think that that's extremely crucial, and yet I see that this mandate does not always take place, because we function within the confines of what's called an adversarial system, and winning becomes sometimes everything, and it shouldn't be. Whatever happened to the adage that it's not whether you win or lose, it's how you play the game, and you got to play the game fairly. You can't hide evidence of innocence. You can't cover up. You can't go out of your way just because you can win to convict an innocent man. And I think that this falls in line with what Jay was talking about earlier. Clearly, the Supreme Court of the United States, in a case entitled Brady versus Maryland, this is the Supreme Court of the United States recognized everything that Jay was talking about here. And they said that the district attorney, the highest law enforcement officer, the prosecutor, has an affirmative legal and ethical mandate to disclose to the defense any and all evidence of innocence. And they also said in the opinion that they must turn over any and all evidence tending to show that the defendant may be innocent. And they also went so far as to say that the prosecutor has to turn over not only evidence relating to innocence, but evidence relating to the lack of credibility of the witnesses that he intends to present. And furthermore, the Supreme Court went on to say that the prosecutor must, as an ethical and legal mandate, to turn over evidence that he knows or reasonably should have known. No longer, said the Supreme Court, that the prosecutor can say, I didn't know about the evidence of innocence, it was buried in the police file and I never read it. That type of cop-out just is not acceptable to the Supreme Court and should not be acceptable to anyone in this room or any citizen in the United States. The prosecutor has an affirmative mandate to disclose any and all evidence tending to show that a defendant potentially may be innocent of a crime and turn it over to the defense attorney, and not having to go through everything that Jay so brilliantly came up with in his investigation that established, point after point after point that was matters of innocence that I take it, Jay, was never turned over to the defense. Were it not for your efforts, it would have been dead and buried, and so would the client. And therefore, I say that, I am so thankful to be on the same stage with Jay, and, I just, in summing up, say that this could happen to anyone, and I really appreciate the opportunity to share the stage with Jay, because he did such a fantastic job in investigating this case, searching for the truth, and saving potentially an innocent man from the greatest tragedy, his loss of life and liberty. So let's have another round of applause for Jay. Now might be the time for those many questions that I know people have.
Hi, Mr. Salpeter. I just have a really quick question. I wanted to know how many hours was Marty interrogated before he confessed?
I think Marty was there about 15 hours at least. Right, and you got to remember Marty, was 17 years old. He woke up to seeing, his parents, his mother dead, and his father just about near death. He was never allowed to go to the hospital to visit his father. The detectives lied to the family, saying that he was going to the hospital, and he was being brought in for interrogation.
You had mentioned a 440 motion. How did you get that before the same trial judge or a different judge?
The answer to your question is that the 440 motion has to go before the same judge who tried the case. And a 440 motion, for those who don't know the criminal procedure law as well as you do, is a motion to set aside the verdict. And if that motion fails, then the next step would be to go through the appellate process and to seek redress in the higher court.
Ron, is that true for any trial can be opened on a 440 motion?
Well, certainly not a verdict of innocence, but a verdict of guilty can be addressed in that manner.
Go ahead.
I'd like to address this to both of you. Given your experience in the Tankleff trial investigation, the 440 farce of a hearing, and the result, and given that the Sentosa case will also be in federal court, that they've been given leave to sue the county and the DA's office, and given the number of convicted people who have been exonerated, people convicted in Suffolk County and exonerated through DNA evidence, is it fair to say that Suffolk County, that there's a pattern and practice of selective and malicious prosecution in Suffolk County?
Well, when I read Barry Scheck's, the beginning of Barry Scheck's lawsuit for Marty, that's the basis of the lawsuit, is that there is a continuation. There's been a pattern of when Marty was arrested, and a pattern that still continues today. They had ample opportunity to correct this. Now, the detective that arrested Marty, Detective James McCready, for those who don't know, he's the second coming of Hitler. Prior to him taking Marty's confession, I read that he was cited for perjury. That was the detective that testified that he showed somebody a photo. That's the detective that said that the weapon was found in the house, outside, which was later found in the house. So they had the opportunity, and that's also in the lawsuit. Why was McCready still a detective when he had already testified in the Suffolk County court and he committed perjury?
Thanks. Can I ask, was consideration given to asking Judge Braslow to recuse himself?
No. Not only did he recuse himself, we were not given subpoena power. We couldn't subpoena during this 440 hearing. Every time our attorneys submitted some sort of motion, we were denied. Everything. We were not, doing Marty's case for the attorneys as well as myself was like a scene out of Rocky. We just kept being knocked down. And when you do a case to exonerate a person, the endurance that you need to continue is just amazing, because unfortunately, and I'll speak for Suffolk County, I can't speak for every county, but I will tell you, like Ron said, he went on both sides. I was a former New York City detective. I thought that, this world was on a level, the justice system, until I came out to Suffolk County. But to exonerate a person, it's just unbelievable. I just did something in Arkansas. I helped on the West Memphis 3. And to the district attorney's credit, out in Arkansas, they released the fellows on an Alfred plea. I'm not going to go into the whole thing, but rather than put them back into the court, they exonerated them. Well, they didn't exonerate them. They let them go on an Alfred plea. And one of them, my client, Damien Eccles, was on death row. You don't let a guy walk out of jail on death row. You were wrong. And they did the right thing. Suffolk County.
I mean, you indicated you felt that Judge Braslow's father's connection with the DA was a problem. Was that thought to be a problem before the case was decided by Judge Braslow?
Well, that's a question that really one of Marty's attorneys would have to answer. I will tell you that before we went in, like I stated previously, we were told we were going to lose. But when your 440 judge, his father is a Democratic bigwig, sitting in the same law firm as the head of the Democratic Party, and then he becomes the trial judge for Marty's 440. I mean, it's just doesn't smell right.
I'm Bob Olson. I was a supporter of Marty Tankleff. Who was McCready's attorney when he was charged? Was he charged with perjury at all? There was a hearing or something? And he had an attorney, correct?
Well, McCready was not charged.
What was he? He was tried.
McCready was charged eventually on another St. Patrick's Day.
Beat up.
He was in a bar, and unfortunately someone made a comment about Irish. McCready took the fellow out and broke his spleen. Now, he was arrested. McCready's attorney at that time was Billy Keon.
Okay.
Now, Billy Keon went and decided, let's have a judge trial. Suffolk County, let's have a judge trial, right? I mean, you don't even have to go to court. But Keon, unfortunately, had a car accident. I don't know if he was under drugs or alcohol. Do we know today, Bob? But either way, he was replaced by Tom Spoda. Tom Spoda defended McCready. And of course, McCready was acquitted before a judge. And the guy's swing was broken.
But decisions have to be made to avoid even the slightest appearance of impropriety that really count. And that's what ensures the integrity of the process, because but for doing so, there's always the thought that lies in the back of the popular mind, and that is, why did he recuse himself? Why is he on the case? Even if he's totally involved. And you know what we told our assistant district attorneys: if you know somebody, you're not prosecuting that case. You're not touching that case. You're getting off that case as soon as possible, and that's the right way of doing it. And therefore, no one is subject to criticism, because not only is there nothing wrong done, but there's not even going to be the slightest hint or appearance of impropriety on that issue.
Jay, the basis for the 440 hearing, I assume, was the new testimony, Mike Higginson, the new testimony from the additional witnesses that you identified?
Well, what opened the case to the 440 was, when I first got the case, I went out to Bob Gottlieb's office, and I reviewed the case. I saw two names that were mentioned, Joe Creedon and a guy named Glenn Harris. So I found Glenn Harris. Glenn Harris was in jail. I wrote him. We became pen pals. And I called his mother up first, and I said, I'd like to talk to him. I told her the truth. I'm the investigator on the Tankleff case. Well, he'll get back to you in a little while. He got back to me, he told me he's in prison. So we became pen pals, and he said, you're on the right track. So he's up in Clinton. I said, you know what, I'll come visit you, but please, don't bring me up there for nothing. So he says, come on up. I thought I'm coming up there, that he had information. I went in as a visitor. I didn't have a legal visit. When I met Glenn Harris admitted to me that he was a driver of the car, and he named me two other persons that he was with that evening, Kent, and Peter Kent and Joe Guns Green. And that was the basis where the attorneys filed the motion for the 440, and it was granted. And throughout, once that 440 started, like I said, it lasted a couple of years. I started a tip line. Like any other police department had a tip line, and I will tell you the amount of people, I mean, a lot of Meshuggahs came forward, with nonsense, but so many people came forward that we had over 20 witnesses that testified. Suffolk County never expected what we were going to come in with.
I'm Ellie Adiel. How did these names turn up, the names of the culprits, in the DA's office? How did they get to those names, and why did they ignore pursuing them?
The names came from our investigation. And our investigation, we presented these witnesses. We brought them into court in our 440 hearing.